All right, the court will follow your agreement, grant the motion, revoke, sentence you to 6 years in the prison, give you credit for any time served. Take in consideration night mag number 740285. There's $1,000 fine. Nicholas Lopez, court is calling 2019 CR 0957. State of Texas versus Nicholas Zachariah Lopez.
For defense?
And are you Mr. Nicholas Zachariah Lopez?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nicholas Zachariah Lopez who was placed on community supervision in 2019 CR 0957 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on April 11, 2019 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
This is on the first amended motion to revoke, Judge.
All right, just one moment. Did you review the document entitled First Amendment Motion to Revoke Community Supervision with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
All right, state, you may proceed.
Violated condition number 1, on or about the 28th day of November 2023 in Bexar County, Texas. The defendant, Nicholas Zachariah Lopez, committed the offense of possession of a controlled substance, PG1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we waive the other violations alleged in the motion.
Any objections?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you to 6 years in prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you grant the motion and revoke the defendant and sentence him to 6 years in prison. In consideration of that, the state is going to take into consideration the new number 1. I actually find a cause number for that. Cause number for that new number 1 is night mag 740285.
All right, counsel, is that the agreement?
It is, Judge.
Mr. Lopez, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement, grant the motion, revoke, sentence you to 6 years in the prison, give you credit for any time served. Take in consideration night mag number 740285. There's $1,000 fine. Time and money is to run concurrent. If you would like to be placed in the therapeutic community, I can request that and they'll help you with any drug issues you have. It does not increase the amount of time that you are in custody. Would you like that? It's completely up to you.
Not at this point. No.
All right. Going to show you what's entitled trial court certification and its rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record.
I'm
Yes.
sorry, did you grant him any time for time served?
I gave him credit for any time served.
Okay.
All right, Mr. Lopez, you're gonna have to change your ways. Otherwise, the next time you come back here, you may come back as a repeater or either as a habitual. And if you're a repeater, you know that increases your prison time if convicted. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you very much.
All right, who's here on Luis Henry? All right, we're gonna take a 5-minute break, everyone. All right, after Henry, it's gonna be Hunt, and then after Hunt. So everyone, please confer. Santabanez. All right, thank you. All right, why were you late for court?
I was in the wrong courtroom, Your Honor.
All right. I see this is his first time on the docket, so now you know where the courtroom is. Do not be late again. You understand?
Yes, ma'am.
Counsel, do you have all the discovery?
So Judge, I was discussing with counsel, there was two new cases that were from November of 2023, I think the 28th.
Mhm.
Those haven't been indicted yet. We hadn't had a chance to take a look at those.
All right, Ms. Ferguson, on Santabanez, can I have a 30-day reset for discovery?
Yes, ma'am. We can do February 8th.
All right.
Judge, just so the court aware, those cases haven't been indicted yet, but my understanding is that defense counsel has been put on those cases.
That is correct, Judge.
All right. So we'll see you back on February 8th. Once you sign the reset form, you're excused.
Thank you, Judge.
All right,
Thank you.
good seeing you.
You too. Judge.
Happy New Year.
Happy New Year to you.
Christopher Davis. So what are the pretrial motions that they're issues on.
The only two we haven't agreed to are the motion requesting a list of physical evidence and the motion requesting a list of persons contacted or interviewed.
All right. So with regards to the motion of list of physical evidence, have you turned everything over to the defense?
Yes, Your Honor. After talking with defense counsel, he wants us to narrow it down and label which evidence we plan to use, which we're not going to do, Your Honor. But the list that was provided by the police, he does have, Your
All
Honor.
right, so it will be done if I
Yeah.
order it. All right, we're gonna go on the record. Court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. Could our parties announce for the record for the state,
Alan Jackson for this.
for the defense?
Robert Barrett.
All right, and are you Mr. Davis?
Yes, Your Honor.
My understanding is that the only issues before the court are motions that the state has not agreed to. Is that correct?
Yes, Judge.
All right, what is the title of those motions?
Motion requesting a list of physical evidence and motion for a list of persons contacted or interviewed.
All right, so let's start up with the motion requesting a list of physical evidence. Defense.
Judge, there is an enormous volume of evidence in this case. Just the number of items itself that were seized is in the dozens. And on those items, there are terabytes of data. So it's like a needle in a haystack for us to prepare for trial, trying to figure out what do we need to know, what do we need to be aware of and prepared for. So I'm just, again, like the state said, asking them to narrow it down. Tell me what you're going to introduce so I know what I'm looking at.
All right, state.
The state would argue that under the code, we have provided all the evidence and that any discussion or attempt to limit us by specifying what exact evidence we intend to introduce would be our work product, and it would be limiting us in case something changes in terms of adapting for trial, Your Honor.
I understand that. And counsel, the motion,
Judge, I'm not saying they couldn't supplement that list later.
I hear what you're saying. And I always try to say, is there something that we can work out? Because I understand there's upon volumes of evidence. So state, are you able, I'm going to deny the motion, but I'm wondering, are you able to give him some type of idea of specifically what you all will be using? He understands that if something comes up through some testimony, the evidence that you may not have attended to use, but he has knowledge of it, you may use. But are you able to do that to give him some idea?
Definitely not today, Your Honor, but as we do approach and prepare for trial, we will be able to kind of talk with him through it.
All right, I'm going to deny the motion, but you all are attorneys and colleagues. I'm sure you all will be able to pare down what specifically will be here.
The state doesn't intend to try to hide the fault or anything, Your Honor, so we'll make sure that if there's something big he wants to focus on, we will definitely let him know.
All right. And then the last motion is and counsel, of course, I will set this for jury trial to give you ample time to review that. And I note that the other person who's on this case is Ms. Kramer, is that correct?
Yes, Judge,
Okay.
she's in another court right now.
All right, so the motion for the list of persons contacted or interviewed, that would be, I'm thinking that's your witness list.
Yes, so anything beyond that, we agreed to a witness list, and then obviously if anybody gives us any sort of statement, we agree to turn it over, but if there's somebody, we just kind of have a half conversation. It seems the request itself is more, seems to be looking for like a specific, this is every person I've talked to type of thing.
Well, and again, Judge, we're asking for that because of the volume of people involved in this case, that, there may be witnesses or people that they've talked to that they don't think had anything relevant to say, but I think might be relevant. And I'm not going to know that if I don't know who it was.
Well, everything that, in terms of witnesses, statements gathered by the police, he has access to all of that. And so if we were going to talk to somebody outside of everything that he knows, we would be disclosing that to begin with, Your Honor.
All right, and does this include us in work product or no?
That's what the impression I'm getting is that it's looking to ask for work product, which.
Everybody that they've spoken to is a potential witness, so it seems to me they have an obligation to disclose those anyway.
All right, so state, have you turned over all evidence to defense?
That we currently have, yes, Your Honor.
All right, and I'm assuming that evidence, because it's required to be, I'm assuming the evidence would be any witnesses that they've spoken to.
Yes.
Should be in discovery. If it's not, then that's something we will take up. So it should be in discovery. I'm not going to require them to give you a specific list of everybody that they've spoken to. It should be in the discovery that they turn over to you. Now, if they're providing you with a witness list, then their witnesses need to be in a list. But as far as them giving you every single thing of everybody they've spoken to and writing down a list out for you, that's going to be denied.
And I don't know if we've done the witness list yet, but we did agree with him that for the expert witness list, so we'll be turning over a full comprehensive witness list, Your Honor.
All right. And how long do y'all expect this jury trial to last?
2 weeks.
Is there video?
There is, I don't know, I don't think it's a super crazy
Long?
long one. I do know, and we've informed the court that our victim is coming, she's currently in Nebraska, so she will be coming from, we'll have to be coordinating interstate travel.
All right. Are you in agreement to letting the witness appear by Zoom, or you want them here physically?
I'd like to be here physically, Judge.
All right. So Ms. Ferguson, I need a jury trial date, and it'll be a week-long jury trial.
Judge, I have a copy of the order that discovery motion order that Ms. Braxton and I went over that we've marked up for agreement.
All right. Thank you.
We spent some time going through it.
I appreciate that. And the date for your jury trial will also be your plea deadline date.
All right, Judge.
April 9th is your jury trial date. All right, thank you. April 9th.
Thank you.
I'm scheduled to be out of state starting April 14th, so I think we'd be running up against, that's a Sunday actually, so the
Let me
9th
see.
would be.
And Your Honor, I am out of the state as well.
Okay. What's the other date?
May, we can do May 7th.
All right, May 7th is,
Thank you, Judge.
all right, thank you.
Thank you, Your Honor.
Thank you. Yes.
Okay, we'll be back.
All right, everyone, we're going to take our lunch break. So see y'all back at 1:30. All right. If you can come back at 1:20, we'll take it up. Court reporter needs a break with his.
As this hearing came to a close, Judge Boyd delivered a message that reached beyond the 6-year prison sentence. The court acknowledged that this case was not just about violating probation, it was about what happens when someone continues committing new offenses after already being given an opportunity to remain in the community. The judge's final warning was clear. Each new felony conviction can carry increasingly serious consequences, and repeated offenses may eventually lead to habitual offender status with significantly longer prison sentences. While the court imposed the agreed sentence, the judge also reminded the defendant that the choices he makes after this case will determine whether he returns to court under even more severe circumstances. Cases like this provide an educational look at how probation works, what can trigger a revocation, and why judges often emphasize accountability, rehabilitation, and the long-term consequences of repeated criminal conduct. Subscribe to follow this case and see whether Nicholas Zachariah Lopez returns to court in the future, or whether this 6-year sentence becomes the turning point that finally breaks the cycle the judge warned him about.